Let's join Thomas MacManus, Director of International State Crime Initiative at Queen Mary University, joins us from London. Thank you for being so patient. I know it's been a very long process this morning and we've been dipping in and out of your comments as we've gone. I wouldn't mind getting an overview of how you think the South Africans have presented their case in terms of how it's been very finely divided and presented piecemeal, not just for the court, I think, but also for the international audience.
Yeah, I think that's right, that the lawyers are thinking about the court and they speak to the court, but they're also thinking about who's watching. And their presentation was, frankly, very impressive. They set out in a very concise way some devastating accusations and strung together in such a legally sound way, an understandable way, and also trying to make, some predictions about what might come back tomorrow as a rebuttal. And the way they set it out with the conduct and then the intent, those are the two elements of a criminal case. And then going on to talk about jurisdiction, the link between the rights under protection and the measures required, but also then going into the urgency. And that was one of the most devastating, I think, for Israel's point of view, part of the presentation, laying out why this is urgent, why this needs to happen now, these measures.
Indeed, lawyer after lawyer had a particular part of the argument, of the petition to present. And I was just wondering, of those, I mean, initially Adila Hashim set the scene, did she not, when she just really told the court why they were here and what the main issues were behind the petition and why it needed to be presented in this way by so many lawyers within their band.
Yeah, and every lawyer had a very distinct issue that they were dealing with. So we saw first the conduct, where we have, and interestingly, looking at the conduct, we only saw quotes from UN agencies and UN officers. You have to remember the International Court of Justice is a UN body, not like the ICC, which is independent of the United Nations. So they're using only the evidence of the basically, reflecting back onto the court, evidence of their own agencies, their own officers. And then moving on to intent, which with genocide is usually the most difficult part to prove. But it has been made easy by the declarations by members of the Israeli state. And not just, talking about the intentions that we've seen from pronunciations and the rhetoric from the Israeli government, but trying to link that to the behavior of soldiers on the ground. This, again, is to preempt any rebuttals that might come tomorrow that say that, there's no link between the IDF's behavior and what might be said by government officials. But we see the case from South Africa sets out how that actually, they are intrinsically linked. And moving away from the conduct where we had the UN being quoted, we moved on to the intent where we have the state of Israel being quoted, and then we look at the foot soldiers, looking at the videos and things, and linking those two together in a very succinct and a very impressive way.
One thing that was quite evident was the way in the presentation the lawyers tried to separate the comments made by politicians and by the military in Israel to what is expected of a sovereign state when it comes to protecting the public and also recognising the road leading to genocide and the checks and balances that need to be made before you get to the G word. And yet, many who are criticising Israel right now are saying, well, in fact, both of those angles have merged together. It is the state making those comments, so how can it stop itself?
Yeah, and that is, an interesting question. How are we going to get a state that denies that genocide is happening to stop the behaviour, which is genocidal in itself? But the South African case lays out quite clearly how the pronouncements by members of the government creates this kind of policy that can be inferred by anybody else on the ground and by their own military, that they've created an atmosphere and created a kind of an environment in which those troops now understand that it is government policy to destroy Gaza. And linking those two things together shows the genocidal intent, and is going to be very difficult for Israel to say that that's not at least a plausible conclusion. We're, of course, are not at the merit stage yet, so we don't need to look at any evidence. But to argue that it's not plausible that this incitement of genocide, which is not being punished by the Israeli state, which is another element of genocide, to argue that this is not plausibly genocide is going to be extremely difficult.
One of the things that we did hear from Professor Vaughan Lowe was the argument around the debate that has happened over the last 3 months of Israel continually saying we are acting in self-defence. That was completely, you might say, the rug was pulled from underneath the feet of that argument. When you are an occupying state, you don't have that right.
That's right. You don't have that right. Now, there might be some scope for arguing that Israel is no longer occupying, that they have withdrawn and are sieging instead. But that is something that, you know, on the face of it doesn't seem to be the truth of the case. And the lawyer quoted the Security Council, which says that is certainly not the case. But that is one of Israel's only kind of few legal arguments that they can make, that they can say, listen, the obligations under the Genocide Convention can't interfere with their obligation to self-defense. But as you say, that's a very weak argument at the moment. Self-defense is designed to defend yourself against other states, not to defend yourself against your own territory. So it's going to be very hard to argue that. The other argument they could make is maybe that they have no genuine dispute with South Africa on this issue. Again, the scope for the court is quite wide, what they understand as a dispute, and simply saying that you think genocide has been carried out and Israel responding that it isn't, is enough to establish a dispute. So what they're left with then, I think what we're going to see is Israel speaking to the world and trying to use graphic images, trying to use videos to blame the victim, basically. What Stanley Cohen, the great sociologist, criminologist, would call denial of the victim, saying, listen, we're actually the victim. We're the ones under attack, and whatever we do is justified. And that has no legal weight, but they want to speak to the world while they have this platform.
Thomas MacManus, there, Director of International State Crime Initiative at Queen Mary's University in London. Thanks very much for joining us.